It's 10:01, so we're going to go ahead and get started. I love seeing where everybody's joining us from. I think we have like Wyoming and Kansas and Texas and all kinds of other places in the house. So thanks for being here. My name is Lacey Hensley. I'm the director of the Institute for Coordinated Community Response. We are a program of the Conference on Crimes Against Women. And joining me today also is our program manager, Maya Pridgeon. With a little wave, Maya. So thanks for being here. We love joining you guys for our monthly webinars and seeing all old friends. And so today we are talking about expert witness testimony, and we're really excited. Lots of good information that you're going to hear today. But before we do that, want to talk a little bit about ICCR. We are a program that comes alongside rural communities to help them improve their systemic response to domestic violence. We are a program that is supported from the Office on Violence Against Women. So just no opinions, findings, anything in today's webinar do not necessarily reflect the views of the U.S. Department of Justice. And not only do we have great national training like our monthly webinars, our on-demand e-learning and roll call series, resource library, all of the things, but we also are currently recruiting new cohorts to join our national cohort program. So if you want more information about that, I will put our website in the chat and you can take a look at that. It's a one-year commitment of a team of 3, a prosecutor, law enforcement officer, and advocate. And Maya and I will work alongside you for 1 year of looking at your systemic response, your CCR, and also bring 4 quarterly trainings in person to your community. So again, if you want more information about that, applications are open until October 11th. Is that right, Maya? October 11th. Okay, great. Thank you. Also, you'll see one of the bullet points there is the CACOS Summit, Beyond the Bounds. We are going to South Padre. We'll talk more about that at the end of today's webinar. So without further ado, talking about friends, today we have Margaret Bassett. Margaret has been a longtime friend of the conference and ICCR and me, and I love her to death, and thank goodness she's here. I've actually been through this 3-day intensive training that she'll talk, I'm sure, a little bit more about in her presentation today that she offers for expert witness testimony. So, Margaret, I'm going to let you take it away.
Okay. It wasn't letting me share. Hold on. Okay. Give me a few clicks. And there we go. Are y'all seeing my first slide? All right, perfect. So welcome for that. These are just my disclaimer slides. So I work at the University of Texas, the School of Social Work at the Institute on Domestic Violence and Sexual Assault. We're a research institute, and we do action research, right? So we do, what are the questions that the people have in the field that they need answers to in order to provide better services, in order to help victims, survivors, in order to move the field forward. And then we are able to help with the research to help answer those questions. And we're able to provide, and part of that is through some of these trainings, provide those answers to the communities that will use that information. I've worked in the field since the 80s, in the field of interpersonal violence since the 80s. And I've done a range of jobs. I've worked in shelters, resource centers. I'm a licensed professional counselor. And most recently, since 2015, I think, I've been providing these expert witness trainings. And the expert witness trainings, we offer anything from this 90-day introductory to up to a 24-hour intensive training on the use of expert witnesses. And the more intensive training allows for participants, those who can serve as experts and those who would use experts in these cases, the opportunity to practice the skills that they learn through the course of the training. It's a training that I'm able to offer. If anybody is interested in trainings, please feel free to reach out to me. My email will be on the end, at the end of the slide on this. So what I really would like for us, for everybody who is here to get from this training, is to really start shifting the focus onto abuser behavior. And taking it off of victim behavior, understanding that the abuser, the perpetrator, the defendant, the predator, like that behavior influences the victim or survivor behavior, and being able to explain that. To really increase understanding of sexual assault, of intimate partner violence, and human trafficking in criminal justice settings, and how experts can be helpful in these cases. And then to talk about why would you use experts, right? And that's to help address things that are seen as tough case elements that experts are able to provide alternative explanations for. Feel free, like with the question, if throw questions out there, I'm happy to answer them as they come along. There are some specific takeaways that I hope people are helpful for people. There's one slide in particular that if you take away nothing but the information on that slide, I will be happy. The other piece of it is pay attention to who's here. I was trying to capture people's names and where they work because I'm like, oh, I want to reach out to them. There's also some people that I saw who have registered that I know, and I saw you all and smiled as your names came up. This is what I call my trigger warning slide, and this is really, it's my communication slide. This work is hard, and all of us work in different settings that operate with their own systems and the push and pull around that. And what I really want us to remember is the important part is it is about communication, that sometimes we are working within our setting, we're doing what it is that we do, and that can have an impact on someone else, and we may not know it. So it's about communication. I also like this slide because it makes me smile when I look at it. So there's several reasons, right, that we want to use experts in these cases. And here's the thing with interpersonal violence cases. It's not uncommon that people are going to have opinions about domestic violence, about sexual assault, about human trafficking, or about stalking. All of you who have worked in this field, when you have been somewhere, either at a family gathering or at a party, or you're at a bus stop and you're striking up a conversation with somebody, and you talk about what it is you do, and you may hear responses like, oh, I could never do that. If somebody did that to me, or if somebody tried to do that to me, I would. And they always have an idea of what it is that they would do. And this comes from people's experiences. This comes from how people view themselves and how they really want to view themselves. And it comes from a place of wanting to feel competent and in control, right? That bad things that I, as a person, have the resources and the ability to interfere before bad things can happen. So people are going to have these opinions. What we know through the research, right? So the opinions are going to be based on bias. It's going to be based on myth and misconceptions about victims, about perpetrators. What people who can serve as experts can do, we have education, we have training, and we have experience. So we've developed specialized knowledge where we understand battering and its effects. We understand the impact of trauma. We can help provide context for behavior that might seem counterintuitive. And then we can also talk about safety planning. We can talk about risk assessment and really provide this nuanced understanding about the role of power and control in abusive relationships. So as experts, we can give opinions in court. The opinions that we give are going to be based on our education, on our training, on our experience, or a combination of all of that. And we're not brought in to provide opinions about everything, right? So we can't come in and say, oh my gosh, you know, that person is lying and that person is telling the truth. You can't go in as an expert and say, well, that person's guilty, or that person isn't guilty, or that person's responsible or liable, whatever it is that the fact finders need to make a finding on. So what we do, we come in and we provide testimony, and our testimony becomes part of the evidence that the fact finders will use in making the ultimate decision in the case, right? So the ways that we can help aid judges and juries to think of an expert as somebody who can help translate information for the jury. So the jury can hear some facts and evidence, they can hear some information, and they may have an idea of that, right? So say in a sexual assault case, it wouldn't be uncommon that a person would think, man, if anybody tried to sexually assault me, I would fight to the death. I would kill them. I would run away. Like, we have all these ideas, right, of what it is that we would do. And your jurors are going to come into the court system with those same thoughts, those same ideas. So as experts, we can talk about trauma. We can talk about the impact of trauma. We can talk about risk assessment and how somebody may choose, or their body may respond out of not through a conscious choice on the part of the person to not fight back, because fighting back would increase the threat to their life, right? So what we know in a traumatic experience is that the person is going to respond from a place of survival. If it's a sexual assault, it might not be about avoiding a sexual assault. It's about living through this experience. And so they may not fight back because fighting would escalate the danger or the threat. So being able to help normalize victim responses in turning those myths and misconceptions into practical evidence, right? This behavior actually is more indicative of a traumatic reaction, or that somebody who stays with somebody who is abusive, that means the abuse isn't that bad. It might mean the abuse is so bad that leaving is not something that can happen right then, because it would lead to an escalation of threat and risk. So all of that really can help connect the dots and pull the evidence together in a way that can challenge the myths or misconceptions that people have about victim and perpetrator behavior. So as experts, think of our jobs as educating the court. So we're up there providing information, and the information that we provide, it has to be accurate, it has to be reliable, and it has to be unbiased. And so the information comes from the research, right, in the social sciences field. And so we have this information that gets distilled down to the practitioners, to the people who are working with the people who are experiencing these who are experiencing this violence in their lives, right? And as experts, then we can help to provide more nuanced understanding about, say, domestic violence. We can help talk about the impact of the pattern, the coercive pattern of behavior that can happen in a relationship that gives that takes control away from the victim or survivor in the relationship and gives in the person who is using those strategies, they end up having more and more power over their partner in the relationship. And part of it, the other part of it, right? What are the strategies that somebody who is intent on this, committing this abuse or this violence, what are the strategies that they use that help make it work? Help make their behavior work to give them that power and control. In where experts, the times that you will want to bring experts in, right? It's what we're really wanting to do is talk about the dynamics, both the victim and the defendant, and the nuances involved in the behavior, right? So for people who would use experts, the more you consult with experts and educate yourself on the nuances of the crime, the better understanding you're going to have about the victim behavior, and also about the defendant behavior. So for example, in cases that involve intimate partner violence, somebody who is abusive, they have to have contact with their partner. And if they can't have direct contact, then they will try and get that contact through a proxy. And sometimes the legal system, whether it's a criminal justice system or the civil system, is one way to access that contact to maintain that control over their partner. So you can find experts. When you can use the experts, it's to help to explain things that the general public may have an idea about, but it's an uninformed opinion, if you will, right? So one, to help keep the focus on the abuser's conduct, on their behavior, to talk about trauma and the impact of trauma, or the lack of trauma, that somebody is actually thinking through these steps, that somebody has good recall to their their frontal lobe is in full control of how they're thinking and of their behavior. To talk about consent in cases of sexual assault, it's not going to be uncommon that consent is going to be an issue in the case, and experts can help talk about consent and can help dismantle some misconceptions that people may have. Experts can also talk about lethality and risk assessment. And they can be used, you can use them in protective orders, in pretrial or evidentiary hearings. You can use them in guilt or innocent or during punishment phases of the trial. It's also helpful for people who for people who can serve as experts. You can be a consulting expert, you can be a testifying expert, right? And as a consulting expert, so those of you who would use experts, start building those relationships with the people in your community who have this expertise, and talk with them early. Talk with them about what you see as issues in the case. What are the hurdles, or what are the tough case facts that you feel may need to be addressed? The earlier you talk with experts, the better understanding you'll have about your case, the better understanding you have, the better questions you're going to ask the victims in the case, and the more likely they will see you as somebody who is helpful, right? The better questions you ask, the better they think you understand, the more they see you through a lens of safety, right? Because somebody in an abusive relationship, it is about safety, and they are quick and they are very skilled at assessing who is somebody who can help them maintain their safety, and who is somebody who's going to help put them at increased risk. So So who can be an expert, right? What are the different, let's talk about the different types of experts, right? So part of that, when we talk about the types of experts, somebody who's not involved with the case, or somebody who actually is involved with the case, not that they've provide therapy or advocacy for the victim, for either party, right? But they have access to, they can do an assessment, they will read the evidence, they may sit through the whole trial and listen to all of the evidence that's presented to the court. Or as a general or pure expert, you may come into the case just to provide general information about specific topics. You're not involved with the case, you haven't interviewed anybody, you may know the names of the people just to kind of rule out any potential conflicts. And you're up there as an educator. You'll have some information about case facts, but you won't be testifying to the case facts. And the questions, how you will be asked for information will be through hypotheticals. The attorney will ask hypotheticals. As a specific or applied expert, then you may actually be asked about case-specific information. In what I have found, when I've been retained by the prosecutors on a case, generally they want me as a general expert. They just want me to provide educate the information, or educate the fact finders about myths and biases, about trauma, about safety or risk assessment, about victim behavior, about perpetrator behavior, things like that in general. And then typically when defense counsel has retained me on a case, they want me to interview people, they want me to look at the evidence, watch interviews that have been done by others, and read whatever evidence is in the case. So the important part of that for people who would serve as experts is to know how and why are you being called. So who can serve as an expert? Well, the types of experts that, so we're going to talk, I'm going to show a video, and then after the video, I'll talk about the federal rules of evidence. But people can serve as experts if they have specialized knowledge, if they have more information than the general public about a topic that is reliable, and that that information would help the trier of fact better understand facts and issue, right? So you can be an expert educationally, right? You can have a PhD, you can be a medical doctor, you might be a degree, you might have gone through a program where you have a license to practice therapy. Forensic nurses have advanced training to be forensic nurses. You can also achieve expertise through your experience, through the work that you've done, and that's part of your experience of work, and it is part of the training that you've received. So advocates, shelter employees, directors of centers can be amazing. Jan Langbein from Genesis in Dallas, Texas she's a CEO of they have a great program. But she is somebody who, I know she's served as an expert witness before, and she does an amazing job. I'm focusing a little bit on directors of centers because they have to be, their expertise, they have to know this information, and they have to be able to educate a wide range of people about the nuances in this, because what they're doing is they're going to people, they're going to foundations, they're going places, and they're asking for money. So they have to really understand the issues in these topics. So they're kind of a hidden gem for people who could serve as experts. Law enforcement, man, when law enforcement has the training and they've got the experience where they really understand the nuances and they can speak to perpetrator and victim behavior and the impact, Maybe they've taken some specialized training on defensive injuries or on, they can, and if they're good at educating, they can be just really amazing experts. Same thing with nurses. The other thing with the medical profession is, for the most part, their experience, they're dealing with people who have just, they're they are always dealing with people who are unhappy because people come to them or they see people where something has happened. They're not feeling well. They're not at their best. And they have to be able to quickly establish rapport to be able to provide effective help to somebody. So they can, all of that, for any of the medical people out there, you have training in how to stay out of power struggles with people, which can be helpful on the stand if one of the attorneys is trying to challenge you and dig at you and get under your skin. Being able to stay out of those power struggles can be really helpful. So we've talked about the types of experts, how experts can help, who can be an expert. And so the first part of that then is you have to be able to qualify as an expert. So this next slide is, I'm going to show a video from my cousin Vinny, and it has nothing to do with violence or assault or anything. It's somebody who is going to qualify as an expert in general automotive. And they are being called because the opposing counsel had called an expert on the case. And so they're calling this expert in general automotive to be able to rebut that testimony. So in that video, there are a couple things. Opposing counsel was a little condescending toward her, right? You worked in a garage. And what did you do in a garage, right? So sometimes when you're testifying, there might be an edge or a certain way somebody is saying something, right? Just to try and dig a little bit at it. The other piece of it is when the question that he asked her, and she said, that's a bullshit question. Now, that needs to be your inside voice when you're testifying, because you don't really want to say that's a bullshit question on the stand. But the importance of understanding the bullshit question, right? That's a question that comes at you where the underlying assumption is false. So, for example, did you know that the client stopped using drugs, right? So the assumption is that the client used drugs, and that could be a wrong assumption. If you answer yes or no, then there's an implication with that. So listening to the questions that come up is very important. The other piece of it that's important to pay attention to is the attorney understood enough that the attorney could look at the evidence and could understand what the evidence is actually showing, and be able to ask the questions appropriately, right, to pull that information out from their expert. So that's a good clip as far as how do you qualify as an expert, right? What is your experience? What is your education? What is your training? And then can you translate that information in a way that will be helpful for issues in the case, right? So it has to also be germane to the case. So that's just a pretty good example. The first testimony, right, that the first in the rule of evidence, the first type of testimony that's discussed is lay testimony, right? So that's going to come from somebody who has personal knowledge of something, and they're not testifying as an expert. They can offer an opinion if it's based on their perception, and if it can help understand their testimony or affect an issue. So they're really relaying something that they saw, that they heard, that they smelled, that they tasted, that they touched, that they did or experienced personally. And so, the case, there may be some sense, there's a scent that they had, let's just say freshly cut wood. And so they know the difference between, say, pine wood or walnut wood or cherry wood. Like, they understand that different woods, there's different smells to that, and that could be important in a particular case, and they're able to talk about that information, not as an expert, but however it is that would come out. So they yeah, so that's a lay witness, right? So an expert witness is somebody who, they're qualified as an expert by knowledge, by skill, by experience, by training, or education. And the or is the key part, because you can have all of that. You can have knowledge, you can have skill, you can have experience, you can have training and education, or you can have one of those. It can be experience. You've worked in this field in this role for 20 years and you have this experience. You could if you qualify as an expert, then you can testify in the form of an opinion or otherwise, right? As a general expert, if your expertise, right, is the scientific, technical, or other specialized knowledge. So when we're talking about interpersonal violence, cases involving interpersonal violence, what we mostly are going to be talking about is going to be specialized knowledge. Scientific or technical can so law enforcement, somebody who on DWI cases, law enforcement might be called in about a case, and they may have to testify to their scientific or technical knowledge of the information that they're saying. Forensic nurses or medical professionals may have to speak to the scientific or technical knowledge that they have, and they also have the specialized knowledge. So like I was saying, they can qualify as experts, and how they are qualifying, what impacts that is how the attorney will ask the questions, because qualifying somebody through scientific or technical expertise will be different. The questions will be different if somebody is qualifying through specialized knowledge. And all of that information, then the attorney has to show that the information that person will share, their qualifications and what they're going to speak to, is going to help the trier of fact. It's going to help the judge or the jury to understand evidence or to determine a fact and issue. And so that goes to, the expert, if they're basing an opinion, it will be on facts, or it's going to be data that the expert has been made aware, they've reviewed, or they've personally observed. And then you have to show that experts in that particular field would reasonably rely on that information. So an example of that in intimate partner violence cases would be talking about the power and control wheel, and being able to talk about how it was developed, where it came from, and how it's used. It is a tool that is widely used in the field of intimate partner violence. So somebody can qualify as an expert. It is the judge who allows that expertise in or not, who will accept all of the information. The judge is the one who has to say, okay. And somebody can qualify as an expert in one case, and they may not qualify in another case. When we talk about admitting an expert to be able to provide expert testimony, We're talking about they have to qualify. So through their qualifications, through questioning them, about how did they become or have this earn the specialized knowledge, if you will. Is that information reliable, right? And is that information relevant to the specific case at hand? So in testing, if we're talking about testing qualifications, right? Does that expert, the person who's being presented, have sufficient background in that particular field? And does it go to is it relevant to the case? And is it relevant to the opinion that the expert is going to be given? So this is about, being able to qualify, and on here are the cases that go to support the admissibility of expert testimony. That part is for the attorneys who may be on this call. So, for example, you may have an expert, somebody who has general information about intimate partner violence or about sexual assault, and then you have somebody who has not only experience but also has specific training on trauma and on the impact of trauma and on helping in working with people on trauma. So they've got, they come from a specific theoretical background in that. So a general expert may not have the same level of knowledge about trauma for the issue in the case that you are pursuing. In the hard sciences, these are the questions that they're going to be asking, right? What is the validity that's underlying the scientific theory? What about the validity of the technique that you use to apply that theory? Has it been accepted? What are your qualifications? What is the literature? This is for the hard sciences, right? For social sgoing or others, the specialized knowledge, you're going to be asked about what is your field of expertise. So you're going to have to be able to define your field of expertise. Is it legitimate? Well, is the field of interpersonal violence legitimate? Yes, it is legitimate. There's over 40 years of research and billions of dollars spent on research. When we talk about interpersonal violence, if we're talking about intimate partner violence, child abuse, sexual assault or stalking, when we're talking about these issues, what we are talking about, the information, how we have the information about these topics is multidisciplinary. Right? It comes from medical, it comes from legal, it comes from psychological, it comes from social work, it can come from policy, it can come from anthropology. So it's an amalgamation of information from an array of disciplines. And will my testimony, or whoever's testimony, will it lie within the scope of the field? And would I have relied on or utilized accepted principles of the field? And so that question, right, it always needs to be yes, that is what you are able to testify to. And then what has to be shown is, will that testimony, will it help the fact finders as they look at the evidence in the case, right? Will the jury be able to, will they be able to understand evidence? Will they be able to better determine a fact in issue in the case? And if the testimony isn't relevant, then it needs to be excluded, right? It's not going to be a part of it. So that's the part that, through the qualifying piece of it, is presenting this information to the court, right? Because they're the gatekeeper and they have to allow or disallow the expert. So for prosecutors, for the attorneys who might be in the room, you have to make sure you've got the right expert for what it is you're looking for. So for example, I'm not I wouldn't consider myself an expert in child abuse. I do have expertise in talking about the impact of witnessing abuse on children. So that would need to be very clear, and I would not testify as an expert on child abuse. I would try and link that attorney with somebody who is an expert. This is where the consultation is so important, is being able to understand the expertise that your expert has, and also in being able to really understand the questioning, so that, because there can be words that have different meaning in different systems, and really being able to understand where what it is that the attorney is asking about and how they're asking, and for the expert being able to understand the context that the questions are coming in. And for the prosecutors, again, you want to make sure you are pulling out those qualifications that the expert has that are relevant, that are going to be relevant to the to their testimony and to the case, what you want to bring out. The attorneys need to articulate why the testimony is relevant, and people who could serve as experts, you need to be able to also understand and articulate why you are there, what it is your testimony in general will be about. You have to understand that before you get on the stand. Admitting otherwise inadmissible underlying facts or data. Again, this is information that is specific for attorneys, and for the experts, when you're on the stand, you might hear objections. If you hear an objection, you need to stop, don't answer the question, wait to hear what happens. Again, the court will be making rulings on the information that may or may not be able to be shared. So for
Margaret,
forensic nurses,
Margaret,
well, yeah,
I'm sorry to interrupt you. We have a couple questions before we move
okay.
on to forensic nursing. Is that okay?
Yeah,
So
I heard a
someone
voice and
asked,
I was like, who's that?
someone asked if you could talk about the difference between being unbiased and providing an expert opinion.
Sure. So, and that's a great question, because people, advocates can be very, advocates, you are really, you're moving towards something, you're fighting for something. And when you serve as an expert, you can't be an advocate. Advocates are great. There's nothing wrong with advocacy. You just, when you're testifying as an expert, it has to be unbiased. So when you're testifying, you're not trying to, you're not trying to convince anybody of something. You're not advocating for an outcome. What you're doing is providing information so that people who have to decide the outcome have the information they need to better accurately assess the evidence. So in general, you see, you don't have a dog in the fight. All you're doing is you are educating the court. You are providing information. You're not saying that this person was controlling and that person was controlled. What you're saying is that there's a pattern of behavior that gives one person control over another person. Here's how that can play out.
Great. And that's a lot easier when you're a general witness than when you're a fact witness and know the survivor.
Yeah.
Then we have one more question. Someone said, I noticed that you didn't list lived experience under experience. Is having survived IPV considered experience?
So, yes, that's a great question. Couple things with that. One, it wouldn't be uncommon that people in this field may have experienced in some form or fashion, personally, a friend witnessed it, family member, whatever, has some experience with violence. And that's just looking at the sheer number of people who, what we know through prevalence studies, about how common it is. So it's not going to be unexpected. Now, you may be asked about it when you're on the stand, and your attorney may say that's not relevant, and they might get overruled, and you may have to acknowledge that. So if you are going to serve as an expert witness, you have to be comfortable. First, you have to talk with the attorney about your experiences, and you have to be comfortable talking about it. And part of being comfortable talking about it, so you have to be in a place where emotionally you are able to talk about it in a way that is in a way that you're not responding from challenges around myth and bias. I didn't say that very well. You have to be confident and comfortable talking about it, and understanding that your experience, your personal experience, actually adds a degree of depth of understanding to what you know through training, what you know through education, what you know through your professional experience, if you will. So personal experience absolutely can add this amazing depth of understanding. And as an expert, if you're testifying, you have to understand that piece of it, that it adds, it really just adds to the fullness of your experience. And you have to be really comfortable being able to say, no, that I'm not biased because I experienced a rape or whatever it was. Did that answer that question?
I think that's all for now. So we'll see.
Okay.
Yes,
Yeah. The thing is opposing counsel is always going to challenge your qualifications. You're not qualified enough. And if you do have a lot of qualifications, you're biased because that's all you have. So, you've worked so much in the field that clearly you're biased. You're not, thinking that interpersonal violence is wrong, that harming somebody is wrong, is not being biased. I mean, I don't know that people would say, oh yeah, I think it's great. I think it's great that you harm people you say you love. That's a wonderful thing you should do. So that's not being biased. It's being aware of when you're challenged around something and how you're able to respond in a way to really minimize or undercut the implications that they're trying to put around that. Yeah. So for forensic nurses, you will be challenged, right? You will be challenged that what you're doing, you're part of the legal system, you're part of the law enforcement. That's all you're doing. And so for the forensic nurses, it's really being able to stay front and center with the fact that you are a medical professional and you are providing treatment. That is the very first thing. That is what you are doing. And you are collecting, and you collect evidence. So forensic nurses, you will get, there are some specific areas that you will get challenged around. And, you're not getting defensive around that. They're asking a question and you just listen to the question and you just answer truthfully to that. Same thing for law enforcement, right? Especially if you participated in an investigation. So you may be asked certain questions, you might have to testify about certain things, and you might have specific expertise, maybe in regards to defensive injuries or something like that, or you have specific expertise on drugs and alcohol, that you've gotten this specialized training and it helps you to do your job better and it allows you to be able to testify as an expert in particular topics. And for licensed mental health professionals or for advocates, people who have where it really comes from this practice experience. So forensic nurses in law enforcement may, because of their roles, they may be lay testimony and expert testimony because they have limited engagement with the person. Their role is very specific, but they have this vast knowledge that they can relate. As a licensed mental health professional or as an advocate, if you've worked with a person, it is really hard, and I would encourage you to be careful testifying as a lay expert and an expert witness, because your involvement in your role with that person is different. You are establishing a longer term relationship. You are working on trust. In that's part of the role, right? That's part of your role as an advocate. It's part of your role as a therapist, but trying to do both and then be an expert on the case, it's very complicated. It's very hard. And I would encourage you to think through that piece of it. Now, you might get involved in a case where you provide an assessment, and the assessment is part of how you're going to testify, and you've looked at other evidence in the case. That's very different, right? Because you're not providing those long-term services to this particular individual that you're providing testimony on. So as experts, go ahead.
Oh, this is perfect because we have one question about this and you may address it. Somebody asked, should we as lived experience experts list that on our CV? What you said, I'm not biased because of my lived experience. So if you don't mind addressing that when you're talking about this.
Yeah, that's a great question. And I think I don't know that I would list lived experience on my CV. I may list it in my bio. But if you put it on the CV, right, because with the CV, you're putting what you've done, trainings that you've gone to, where you've worked. And so the flow of the CV is like from this date to this date, or, you were in school and you did this or that. And so it would, if you can fit it in, if you can put it in there in a way where it reads well and isn't kind of disconcerting, right? Because it's a little more narrative than it is, I was abused from, 1983 to 1987. It seems like it would be hard to put that personal experience in there without the parameters. Like I would put my job experience in there with parameters. Sorry, I'm processing out loud. It's a good question. I hadn't really thought about it. So your CV really, it's about your qualifications. So what qualifies you, and experience of interpersonal violence isn't necessarily enough to qualify you as an expert, right? You have to be able to share your experience in the context of what we know about that issue or that particular experience. So in the research, right, what does the research say or whatever? So it's really more narrative in fashion, if that
Okay,
makes
thank
sense.
you.
Yeah, I'm happy
Then,
to have conversation with that afterward too. But here's the thing with your CV, start documenting soon, like start documenting right away. And what you're looking at, what are the experiences that you have that show that you do have expertise in these topics, whatever the specific topics are, right? Whatever the training is, or whatever your degree is in, or what your work experience has been that gives you that expertise. If you've published anything, then you want to put that in there. If you teach, whether you're teaching or whether you're providing trainings, you want to document those. And if you've testified as an expert before, you want to go ahead and put that information in there. Yeah. And what I do is I keep, like, every month I'll go back, I try and document everything in my calendar that I've done. And then I'll go back and try and update it every month, just so that I can stay on top of it. So experts in intimate partner violence cases, what we can talk about is batterer behavior, coercion, power and control. We can talk about the role of fear, talk about recantation or denial, minimization. What are some common victim responses to batterer behavior? What are some strategies that somebody who's abusive may use? Being able to talk about the power and control wheel, not as a prescriptive tool, but as a tool to help understand that somebody who is abusive will use these strategies that may fall in these categories, although there's other categories that could be in there. And just being able to talk about it and educate people about how that particular tool might be used. So the most dangerous myth, this isn't the slide yet that I want you to walk away and remember, but this is a good one, right? The most dangerous myth is that the victim is responsible for the abuser behavior. The more common response is for the focus to shift off of the abuser's behavior and start looking at the victim or the survivor's behavior and judging that behavior. And there's a variety of reasons why that happens. And as experts, our role is to help challenge some of those myths that feed into that, right? So what are some of the myths? Is that if somebody leaves an abusive relationship, the abuse will stop. It can't be that bad if somebody stays. These are all myths, right? Well, did you see what they were wearing? They went into the hotel room. Like, clearly they should have known that should have happened. Or yeah, they wouldn't have texted the person who they're now saying sexually assaulted them, or they wouldn't have gone out with their friends, or they wouldn't have gone to work, or they would have gone and gotten medical care. So these are myths that people have about what victims could and should do. And this is a slide, if this is the only thing you walk away with, this is a slide I want you to think about. And remember, is that the only reason that a victim is beaten, is raped, is stalked, or is trafficked is because she met a batterer, a rapist, a stalker, or a trafficker. If that person had not met somebody, it would not have happened to them. And we have to understand that is the only reason that this happened to them. It's saying I might have, hold on. Can you guys see my snooze update? So when we talk about effective testimony, I'm getting something that says my computer might restart. So if it does, I apologize. I'll log back in real quick. When we talk about serving as an expert witness, right? So what is effective testimony? So effective testimony is unbiased, right? What we are doing is we are educating, we are sharing information. We're not trying to convince anybody of anything. The language that we use, it needs to be very clear. It needs to be compelling language, and we need to keep it simple and we need to keep it short, right? We don't we don't have the time and we're not able to, there will be an objective to go into a narrative about something. We also want to use relatable metaphors. So for example, I'm originally from Michigan, right? And so I might not use a metaphor that involves a moose in Texas because Texas, as far as I know, doesn't really have a lot. They have deer, so maybe I can use a hunting example with deer. And in the video, you saw she used a metaphor that where she talked about the tire in the mud and what happens, and you could see the jury, they were nodding. They're like, oh yeah, that has happened to them. You want to be thorough and accurate. The things that saying something like, well, I think, is not, as an expert, when you're on the stand, when you're testifying, it's not about thinking. In my experience, through my experience, so you want to be very clear with the language. The other thing, I don't know, that is beyond my expertise, or I can't recall, I don't remember. Those are accurate answers. If you don't know something and you never had that information, then you don't know it, and that's an answer. You don't remember means you had the information at one time, and perhaps your memory could be recalled. The other thing, so if you're going to respond to academic literature or to studies, make sure you can cite them accurately, and make sure that you provide that information to the attorney who retained you. And make sure you're using statistics and information that are accurate. I still hear people talk about the fact that women will leave 7 times before they leave for good, will leave an abusive relationship 7 times before they leave permanently. And, you know, on the one hand, that the question is not leaving, does it mean the abuse ends? So being, you know, how are you really working with the attorney around the information they're trying to get? And the other is, I don't know that there's specific research that says that. I think that's language, that's information that came into being, and people just kind of rely on it and repeat it. So if you're saying something, make sure you understand where it came from, and you actually can trace that, if that makes sense. The other part, I'm not sure. So the other thing when you're testifying is you want to consider word choice. So for example, intimate terrorism. When I first started these trainings back in 2014, when I became a part of the trainings and we were talking about this, I love intimate terrorism and the definition of that and the implication of that, because it is terrorism right? And there is more research. In 2014, like using the language of intimate terrorism with intimate partner violence, would be no, right? It would, the focus would then become on that and on terrorism. And aren't you, don't you just see abusers and terrorists everywhere? And it would have been ridiculous to use that. But actually, in the research, they're actually using the language of intimate terrorism. I still wouldn't use that when I'm testifying. But that also points to how our understanding and knowledge in the field changes over time. So for example, I'll jump to battered woman syndrome, talking about in 1978, it was 78 or 79, Lenore Walker wrote the book, The Battered Woman. It was seminal work. I mean, it pulled information together. It really kind of advanced our understanding. It was a catalyst, if you will. And then over time, we gathered more information. Like we started having more questions and we started gathering more evidence, and there's more research. And then in 1984, we're talking about power and control, and we're not talking about a cycle of violence, and we're not talking about battered woman syndrome. We're starting to shift the focus off of the victim's behavior and onto the batterer's behavior. And I think it was 2007, where they talked about battering and its effects and how we can start you and how we need to start talking about these issues in that way. Um, Another, like, are you going to say rape? Are you going to say sexual assault? There can be legal implications. The attorney will talk with the experts about that piece of it. But part of it is being able to explain, not defend. You're not defending anything. It's being able to explain the language that you're using, and communicating that with the attorney. That goes toward when we think about victim or survivor. When when prosecutors call me and I'll talk about victim, and invariably opposing counsel is going to say, Your Honor, can she please say complaining witness, right? Because they don't want me saying victim. Now, in the advocate field, victim or survivor can have really impactful messaging, and it's important, right, to process through all of that. In the legal system, not so much. It's not the same. It's not the same issue, if you will. Male privilege, it's on the power and control wheel. When you think about word choice, there are hot button topics or words that that have profound implications, and being able, if you're going to use language, if it is important in the case, or it is important in what you're talking about, and you and your attorney are talking through this, it's important then to be able to use that language in a way where you're not going to get bumped into being defensive around it. So just really being able to pay attention to what you're saying and what it means in the criminal justice system. I put choking and strangulation on here as one. There's also times where what I call are easy wins. And it happened in that video clip that I showed you where she was talking about the tire marks. And she said, if it was this, it would have gone like this and you would have seen that. But that didn't happen here. They were flat and even, independent rear, right? So you learn something, the jury will learn something, and that took, I don't know, maybe 30 seconds for her to do something. So being able to define and separate choking from strangulation, you're acknowledging that people commonly say choking when they're talking about strangulation, and you're giving them information, something that they can walk around with. Next time they hear choking, and it's not an internal obstruction, their mind, they're going to be like, oh no, that's actually strangulation or smothering. So there's these easy win moments where you can provide accurate information. When those come up, take them. It'll also build your confidence, and it will lend itself toward your credibility. When you're on the stand, listen to the question that's asked and answer the question that is asked. For example, if I were to ask you, and you're on the stand, and I were to say, do you know what time it is? And if you look at your watch and you say, it's 11:18, that wasn't the question I asked, right? I asked, do you know what time it is? Yes or no? Does that make sense? So that's a good example to kind of keep in your mind when you're assessing the questions that are coming at you. It would not be surprising that you may be asked a question that is very confusing, whether that's done on purpose or because the attorney wasn't really paying attention to the question they were asking because they were thinking about questions 5 steps ahead. Just say that. Can you repeat the question? I'm sorry, can you rephrase the question? Don't worry about taking a breath and making sure you understand the question, and think about your answer. Now, you can't be silent up there for an extended period of time, but you can take a minute to think and to come up with your answer. And remember, you're teaching, you're an educator. So you're helping people to better understand something. You're providing more information. When you're on the stand, you're like interact with the jury. Not interact like ask them specific questions, but look at them, right? You're helping. You want to them to be a part of this question and answer that's going on with the attorneys. Do not get into power struggles during direct, for sure, but also during cross-examination. Like, don't get into a power struggle. You can say, I can't answer that yet. They may ask a question. I can't answer that, yes or no. I need to explain it. And the judge may rule and say, just answer the question, yes or no. So then you have to answer it yes or no. But you've given the attorney who retained you enough to know that there's more you can say on that topic. And if they feel it's important, they'll come back and redirect and ask you about that. So listen to the question, answer the question truthfully. You are not there to win the case. You're not there to lose the case. You are there to provide this information so that the fact finder they're the ones who are making the ultimate decision in the case. And then just what are the ways that opposing counsel might try to divert you, right? Might try to rattle you. To kind of shake you in your confidence in your answer. Part in the video, she came across very confident, even when she said, I'm an out-of-work hairdresser. She was like, I'm an out-of-work hairdresser, right? So answer the questions truthfully. And then at the end, just be confident. You know what you know, and what you have to say matters. What I think anybody who has worked in this field understands is that one person's story may not have power, but the collective stories of victim survivors is what gives power to the knowledge that we have. And in the work that we've done, in the stories that we've heard, that information, when we pair it with what we've learned, can be very, very powerful. These are just some Texas-specific information that we have done in IDVSA. Yeah.
Great. Thank you so much, Margaret. We had one more question. Someone said that what do you recommend if someone wears several hats? For example, advocate, lived experience, mental health professional or practitioner. They get referred cases to provide expert testimony on by both the prosecutor and defense attorney.
What is the exact question? I mean, it sounds like whoever you are, you have amazing experience. And I can see why you would get called by prosecutors who would call because they have a case. And, so all of that, right? All of that is your experience, making sure think of your CV as your paper introduction of you and your experience. And then the other part of it is absolutely consult with the attorney who retained you so that you are clear what it is, what you are testifying about. Are you testifying about dynamics? Are you testifying about safety planning or risk assessment? Are you testifying about stalking behavior? Are you talking about victim behavior, perpetrator behavior? Are you talking about trauma? So it's really having a good understanding, and then your ability to combine all of your experience, education, and training in your responses. I don't know if I answered the question, but.
No, I think you did. I think you did. So I really quickly wanted to highlight, first of all, thank you, Margaret. Lots of great information, as always. And lots of folks, I just want us to start talking more about the use of experts. I think it's something we don't talk about enough. So anything we can do to increase that is great. Let's see, we've got some folks in the chat just Yeah, what great information. We want to share with you, we spoke about this just a little bit. Thank you, Margaret, as always. But we want to shift gears for just a second before we let you go, and let you know about the Cacao Summit. We have never done this before. This is brand new. Some of you know that we have done our ICCR virtual conference every October. This is actually taking the place of our virtual conference for this year. And so we are going to be in South Padre Island in Texas in October 30th, or excuse me, September 30th and October 1st. I can't talk. One of the things that we're focusing on, this is a little different than conference. We are focusing on resort communities. If you live in a resort community and you typically have maybe a population of 2,500, and every weekend or every spring break or every holiday season, your population swells thousands and thousands of people, that really creates some challenges and differences for law enforcement, prosecutors, victim advocates, et cetera. So we're going to be talking about those individual unique things that happen surrounding crimes against women. We're also going to have Andrea Zavaris is our keynote speaker. She is an aquatic homicide investigative expert, medico. I can't recall her title off the top of my head, but she's going to be talking about aquatic investigations, things that look like drownings that were actually a staged homicide. We're actually going to be doing some interactive stuff on the beach. Anyway, we would love to have you there. Check out our website, conferencecaw.org, and get your seat, ticket, registration, all the things. And then finally, we do have some upcoming webinars in the next couple months. On September 19th, we are going to have our Chief Residential Officer, Jordan Lawson, that's going to be joining us talking about the use of shelters, especially maybe if you don't have a shelter in your area, what can you do? So how to effectively utilize shelter services. And then October 29th, we're going to have Julie German and Kara Breeden are going to be talking about adult forensic interviewing. So we would love for you guys to join us for those. More information can be found on our website, coming soon, instituteccr.org. And there's our contact information if you need anything from us. Have we left anything out at all, Margaret? Anything else we need to mention
Yeah,
before we go?
I'm responding to the talking about leaving and returning and the
Mhm.
important, hey, Scott, it was good seeing you too. What's important when we talk about leaving is that people in abusive relationships, they leave all the time, right? They go into a different room. They may go to a shelter for a few days. They may go visit a friend. They might go to work. It might be emotional leaving. It might be physical leaving. You've got the little L leave, and then you have the big L leave. And it's what is that behavior? What is the influence? How does that impact the abuser's behavior? Because when it's about the abuser's perceived lack of control, lack of access to, that impacts what they do, how they respond, which impacts the risk. So we really do need to even think about what that is, because when we say, why doesn't she just leave, it's victim blaming. The second that, and we've all done it, but it's victim blaming, because leaving doesn't mean the abuse ends. So it's
Right.
really, how do we talk about that? And just the impact, because leaving and returning, that increases the perceived power on the part of the perpetrator over their partner, because their partner tried to leave, but they were able to control them back. They were able to maintain that. So it's really how we talk about, how we educate it, because somebody leaves 7 times before they leave, it doesn't mean anything. Somebody leaves 6.3 times. What does it really mean? Right? So the important thing is how we think about it.
That's great. Yeah. We have one more question about any upcoming in-person classes that you're going to be offering in the future. And then I will put Margaret's email address in the chat.
Yeah, reach out and ask me about that, because I'm ending a grant now, and I actually am trying to schedule a few more trainings in Texas. during the week of September 9th. And then I'm happy to talk about I'm happy to talk to anyone else about other trainings or things that we can do. And Shavana, I hope I pronounced your name right, but I requested access to that Google Doc that you put in there. I am so interested. I get calls from attorneys all the time in being able to have a referral list of experts. So that's amazing you're doing that. Thanks, everyone.
Thank you so much. Be looking for a recording of the webinar will be on our website within the next week or so. As soon as you end today and exit out of your webinar, you should get a pop-up to take a survey. Once you take the survey, that will send you your certificate for attending today's presentation. So thanks, guys. We'll see y'all next month. Take care.
Bye, everyone. Thanks for the work you do.